Based on the case, Amin was a chief executive officer and licensed investment advisor of good investment management. Last year, Eve was intended to invest in something fairly safe and decided to engage with good investment management. Much to Eve's help, Amin has assured her that he would, in his professional judgment, personally select suitable investments. Amin also assured Eve that she could rely on his skills and vast experience in the financial market. However, in August of last year, Eve have suffered a financial loss because of Amin's act of negligence. Based on the aforementioned case, negligence occurred. Negligence is a tort which determines legal liability for careless actions or inactions which cause injury. Thus, the tort of negligence spans the whole range of human activity, since it is not concerned with the activity itself but with the manner in which the activity is carried out. Since it is not concerned with negligence conduct is that which falls below an acceptable standard. This standard is established in order to protect others from an unreasonable risk or harm. Thank you.
So the first issue that arises from the case of Eve versus Amin is whether Amin owed duty of care towards Eve. So in this case, it is stated that Eve only suffered a financial loss and not suffered any physical injury, and the defendant commit negligence in giving his advice about investment. So there is a specific area which the courts have been very cautious to impose such duty when it comes to the damage suffered by the plaintiff was only economic loss or pure economic loss. The pure economic loss means pecuniary or financial loss where it was free from any physical injuries. The courts would only allow the plaintiff to make a claimant if there is a sufficient special relationship that exists between the parties. The special relationship means that there is an assumption of responsibility on behalf of the defendants, whether it was in the form of advice and or service that one party provide. So traditionally, the pure economic loss may be happen or incurred because of negligent misstatement, where the negligent misstatement applies to a defendant who owes a duty of care towards the plaintiff but carelessly give a false statement, and as a result, the plaintiff suffered a financial loss. As we could refer in the landmark case Hadley versus Heller, where the plaintiff is an advertising company, was about to enter a contract with their client, FC Limited, for a sum of £100,000 per annum. So the plaintiff had requested for a comment about their client from the defendant, and the defendant replied in writing stating that confidential for your private use and without responsibility of the bank and its officials. Hadley had relied on this statement and suffered a financial loss as the FC Limited went into liquidation. So the plaintiff sought recovery loss from the defendant on the ground of those statements were made negligently and they owe a duty of care towards them. The House of Lords held that there are sufficient relationship that exists between the parties, but since the defendant had disclaimed their liability, so there is no order for damage. So there are three principles that we need to fulfill to establish the terms of special relationship. Firstly, the plaintiff must rely on the advice given by the defendants. Secondly, the defendant must be aware or ought to reasonably know that his advice will be relied by the plaintiff. Lastly, the plaintiff's reliance on the advice must be reasonable. The liability under the Hadley versus Heller principle, since then it had been restricted, starting in the case of Mutual Life and Citizen Assurance Company Limited versus Ever, where the courts have decided that the duty of care would only arise if the defendant is in the business of giving advice and or profess to have expertise in that particular field. However, the plaintiff had asked the defendant for some advice about the soundness of another company, P Limited, and as a result, the plaintiff had suffered financial loss. So in a majority decision, the courts held that the defendant was not guilty and liable for negligent misstatement, as the defendant was not in the business of giving advice and therefore owe no duty towards the plaintiff.
Hi, so I will be explaining on the application of duty of care in the case of Eve against Amin. Based on the question, Eve case can be categorized in negligence of misstatement. In this case, the court requires that the existence of special relationship between the defendant and the plaintiff were formed, and to prove it requires three elements based on the principle of Hadley-Burns case and Abbott's case. The first principle to prove special relationship between the plaintiff and the defendant is that the plaintiff trust and reliance towards the defendant. In this case, Eve fully believe and rely on Amin's advice as she is new to the stock market industry. As someone new, an individual would trust more on professional views compared to others, as they tend to, as professionals are more knowledgeable compared to the others. And in this case, we can assume that Eve believe Amin's as a professional would give her the professional advice that she needs in order to make her investment in the financial market successful. The second element of proving special relationship is that the defendant knows and ought reasonably to know that the plaintiff depends on his advice. In this case, Eve already mentioned to Amin that she is new to the stock market industry, which we can assume that Amin already know and aware that Eve depends on his advice fully. If he did not give Eve the proper information and advice, he should be aware that Eve would lose her investment. And Amin did fail on calling Eve the day of the open listing, because he is outside of state, and also Amin's had mistakenly give the different prospectus compared to what had been shown to Eve. The last requirement of special relationship is that the plaintiff believe and rely on the defendant's advice are reasonable. An advice from a professional individual would really much be a reliable credit to someone that is not familiar to the field. And Amin, who is a licensed financial advisor and a CEO of a financial and investment company, would really much can be said that he is professional and knows about this field compared to Eve. And can say that it is reasonable for Eve to trust Amin's advice, as the statement that was made is from a professional side.
Breach of duty is the second element of the tort of negligence. The defendant who owes a duty of care towards the plaintiff has acted below the minimum required by him, and due to the defendant's improper act or omission, caused the plaintiff to suffer harm. According to Heaven and Fender, the defendant is a dry dock owner who had failed in his duty of care to give a reasonably careful attention to the condition of the rope, and caused harm to the plaintiff, which is an employee of the dry dock. The defendant was found liable because he has breached his duty of care towards the plaintiff. Breach of duty in negligent liability is determined by the objective test. The standard of a reasonable man is the measurement of standard to determine whether there has been a breach of duty of care by the defendant. Reasonable man test is to see whether the defendant's conduct fell below the standard of care which is expected of a reasonable man or not. If the defendant has acted below the standard of a reasonable man, the law says that he has breached his duty of care towards the plaintiff. Because in determining breach of duty, negligence law normally compares the defendant's behavior to an external standard of good. The test requires the plaintiff to act similar to a reasonable person. Like stated in the Vaughan and Manlove case, the defendant haystack caught fire due to poor ventilation. The defendant had been warned on numerous occasions that this would happen if he left the haystack. The defendant argued he had used his best judgment and did not foresee a risk of fire. The court held his best judgment was not enough. He has to be judged by the standard of a reasonable man. This means that he has to take reasonable precaution just like any other reasonable man. According to Blyth and Birmingham Waterworks Co. case, negligence is failure to do something which a reasonable man would do or doing something which a reasonable man would not do. A reasonable man just an ordinary person and does not mean the perfect man or the model citizen. However, the personal characteristic of a person will not be considered. But if the defendant possesses some special and particular knowledge or expertise in a particular field, the reasonable man is expected to be someone possessing the same knowledge and expertise as defendant. To ascertain breach of duty, the court must first ask if defendant have acted in such a way that resulted in breach of duty. The main thing is to recognize the standard expectation of the defendant and determine whether the actions have followed the standard of care or not.
Assalamualaikum. So now I will present about the application of breach of duty that before this my groupmate Ain has explained about what is breach of duty. So now I will explain about how to apply breach of duty into the question that was given to us. So first thing first, we have Amin who is a chief executive officer and also a licensed investment advisor. So he is expected to have vast knowledge about his scope of work. He should be experienced and be knowledgeable. So when we are about to judge him, we should judge him based on a reasonable man, which reasonable man is to profess the same job as him, the one who have the same knowledge as him. If Amin have act below the standard of care, which is a professional, he will be said to breach his duty. Firstly, Amin must be evaluated as the same standard of reasonable man. But since Amin is a professional, as he claims to have excellent skills and knowledge about financial market, so he must be evaluated as the same person who has the same job scope as him. Meaning, the person who also work in financial market also have a license of investment advisor. Beside, Bingham LJ in Al-Kasri and Bini and Partners stated that a professional person should command the corpus of knowledge of his profession just like the other member of the same profession. Secondly, we should also measure the proximity between breach of duty and also the damage suffered, whether Amin had foreseen that his action will cause damage to Eve. So the issue that was raised here is when Amin had failed to give a call to Eve on the listing day to inform her about the opening price. Due to that, Eve suffered financial loss. So again, I quote from Bingham LJ in Eckersley and Bini and Partners, stated that a professional person should be alert with hazards and risks in any professional task that he undertakes. So here, Amin, as a professional person, should have foreseen what risk might be experienced by Eve, and he should have taken any precaution to flatten the risk. To justify, Eve may be able to sue GMI for breach of duty because they had failed to perform their duty in their part, cause damage to Eve.
Based on the above discussion, in order for an individual to take action under the law of negligence of economic loss, the plaintiff is required to prove to the court of law that the existence of duty of care in his legal action. The plaintiff in his legal action in which there is breach of the above said duty, and there is damage caused by the above mentioned breach of duty. And lastly, there is a reasonable close connection between the damage and the breach of duty.